My name is Neil. I'm one of the staff attorneys here at the Public Health Law Center. Just a little bit about who we are for anyone who might be new to the sort of work that we do. We are part of the Law and Policy Partnership to End the Tobacco Epidemic. This is with the American Lung Association. What we do is we work to support tobacco control professionals, like many of the people on this call, in establishing and strengthening tobacco control measures in the great state of California and elsewhere. We provide technical assistance and other forms of support to our partners, and that includes trainings like this one, this webinar. So a little bit more about us. I just want to start by acknowledging that the Public Health Law Center is located at Mitchell-Hamlin School of Law in St. Paul, Minnesota. We are on the indigenous and in the indigenous homelands of the Dakota people, who are also known as the Sioux Nation, and that 4 federally recognized Dakota tribal nations remain in this area. The region also is shared territory for the Anishinaabe, also known as the Ojibwe or Chippewa, and there are also historical relations between this region and the Ho-Chunk Nation. We recognize that historical wrongs and cultural resilience have occurred past and present, and appreciate the ongoing stewardship and spiritual connections and lifeways that were developed and are still practiced in these homelands upon which the law school sits. So a little bit more about who we are. I'd also like to share that the principles that guide our work at the Public Health Law Center. We work to promote equity and the realization of the highest attainable level of health for everyone. In order to achieve that goal, we must look to not only individual health, but also the totality of the circumstances that impact individual health, and what social sciences have coined to be the core determinants for health. Equity recognizes that each person has different circumstances, and an equitable approach is one that tailors the resources and the opportunities needed for each of us to do the work to reach an equal outcome. So I'll also take then this opportunity to note that we're going to use the term tobacco quite a bit, as is our wont in this conversation about flavored tobacco products, specifically menthol. And what we're specifically referring to are commercial tobacco products. And that does not include the important and traditional sacred use of tobacco in some tribal and Native American communities that occurs today. So how we go about enacting on our principles, how we espouse and advance equity, is through webinars like this, through trainings, through technical assistance, as you heard me mention a few moments ago, and as you see on the slide. The Public Health Law Center provides information. It provides a resource for professionals and advocates and curious members of the public. What we do not do is we do not lobby, and we do not provide legal representation or advice. And we always defer to local counsel or expertise for any of those kinds of questions. And so let me be the first to introduce our 2 panelists who will hopefully shepherd us through some of the developments that have happened in the past few weeks when it comes to tobacco measures in the states today. We have Joelle Lester, the director of the Commercial Tobacco Control Program here at the Public Health Law Center, and Natalie Hemmerich, who is the head of the California team for technical assistance, herself the lead senior staff attorney in that role. So Joelle, please take it away.
Thank you, Neil. Oh, sorry, that was a lot of clicks in order to share my slide and my face. Welcome all. We're very glad to have folks working hard to protect health in California communities with us today. And Natalie and I are really excited to speak with you about the FDA's recent proposed tobacco product standards to prohibit menthol cigarettes and all flavors in cigars. This day has been a really long time coming. So what I'm going to start with is, how did we get here? And actually, this slide doesn't even tell the whole story, because starting with the Family Smoking Prevention and Tobacco Control Act of 2009 isn't the beginning of advocates' work on the issue of the targeting of the Black community with menthol tobacco products by big tobacco companies. And so I just want to acknowledge that advocacy and efforts to protect health and prevent targeting were happening all around the country long before 2009. And you can see some familiar faces probably in some of these photos. And what's truly remarkable is that the African American Tobacco Control Leadership Council and the Center for Black Health and Equity, who lead this effort now, have always led this effort. And it has been more than a decade of work trying to fight back against big tobacco's predatory targeting. But we will take this conversation, since it's about what the FDA is doing, from the passage of the Tobacco Control Act in 2009. As many of you know, the act contained a prohibition on flavored cigarettes, which unfortunately exempted menthol flavored cigarettes and tobacco flavored. That was a political compromise and has been called the original sin by Mr. Delonte Jefferson for being a measure that public health advocates also agreed to in negotiating and trying to get a compromise bill through to get the act passed. So while there were many important provisions of the act, and it's really important that the FDA finally was given authority to regulate commercial tobacco products, this omission is a huge problem because menthol drives health disparities more than any other flavor. It is the most harmful, most widely used flavor, and exempting it was a total failure of public health in protecting Black health. So the act did direct the FDA to study the issue of menthol. And they did do that. The act had established the Tobacco Product Scientific Advisory Council, and the first order of business for TPSAC is what it's called. The first order of business for TPSAC was to study the issue of menthol, which they did. And in 2011, they published a report concluding that removing menthol cigarettes from the market would benefit public health. That is an excellent conclusion because it's exactly in line with the public health standard, which is to govern all of the FDA's activities in regulating commercial tobacco products. The FDA is supposed to consider the impact on users and non-users and determine what's in the best interest of the public health. And so when the TPSAC report came out in 2011, it seemed like, well, that's great. Now the agency will move quickly to get those products off the market, but that is not what happened. And so a couple of years later, in 2013, the Public Health Law Center, our team, along with many other organizations, especially AATCLC and the Center for Black Health and Equity, filed a citizen petition with the FDA calling on the agency to finally take this action that all of the evidence required and the authority allowed the FDA to do it. So the second picture in from the left is from April 12th, 2013, when Dr. Valerie Yerger, Mr. Doug Blanke, our executive director, and I traveled to DC to hand deliver the citizen petition to the FDA Center for Tobacco Products Director, Mitch Seller. The FDA did a bunch of other things around the same time to study the issue of menthol. There was a lawsuit filed against the FDA challenging the impartiality of the TPSAC, the committee, so that the agency decided to conduct its own independent review of the evidence. It opened a docket in July of 2013 to gather more information on menthol in cigarettes and other tobacco products. But no regulatory proposal was forthcoming. And as I'm going through this, and it's possible Stephanie's already putting this in the chat because I can't see the chat. Oh, yes, she did. Stephanie, our colleague who introduced herself at the beginning, she also developed a very handy interactive FDA menthol timeline that she put the link to in the chat. So you can go back and see more details about each of these events if you are interested. But after the petition was filed in 2013 and the advance notice of proposed rulemaking gathered a lot more information, and then still the agency didn't do anything, the African American health leaders who had worked on menthol for so long turned their attention to state and local policy change, and so did we. So we all worked to develop resources and do analysis and try to help local communities develop these policies. As you know, or you might know, Chicago was the first community to include menthol in a flavor restriction. So other communities had restricted the sale of flavored tobacco products, but exempted menthol, and Chicago was the first to include it. The policies got better, more comprehensive and stronger up to San Francisco's groundbreaking policy prohibiting the sale of all flavors in all tobacco products in all retailers, no exemptions. So since that time, we've continued to see both amazing policy change at the local level, efforts to follow suit at the state level, and the tobacco industry's response at the ballot and in the courts. And so ongoing continuous struggle. But one of the many benefits of the local policy change and the evaluation data that folks have been able to collect is that it just continues to build this evidence base that supports regulation getting menthol cigarettes off of the market. So after so many years had passed with no real response to the 2013 citizen petition, AATCLC continued their bold leadership in partnership with Action on Smoking and Health, the American Medical Association, and the National Medical Association by filing a lawsuit on Juneteenth in 2020 to force the FDA to take the action it had not taken and respond to the citizen petition as required under law and get menthol cigarettes off the market. The agency at first didn't do very, they resisted, then they got some extensions, and then on April 29th, 2021, in the most welcome announcements ever from the FDA Center for Tobacco Products, they announced that they would get menthol cigarettes off the market, and at the same time that they would get all flavored cigars off the market. And I particularly congratulate the agency on thinking broader than menthol cigarettes. Of course, I think we would have been even more broad if we could and gotten menthol in all flavors out of all tobacco products and at any level, even at the additive level. But it is really important that the FDA included cigars, because as we know, cigars are essentially very similar to cigarettes, especially little cigars. And so we want to make sure that we're delivering the full public health benefit to the most disproportionately impacted communities with this regulation. So just really feeling so much appreciation and admiration for the leadership of Dr. Phil Gardner, Ms. Carol Magruder, Dr. Valerie Yerger, and Mr. Del Monte Jefferson, who are all pictured here. So I'm going to tell you a little bit about the menthol regulation, the proposed menthol regulation, and then I'll turn it over to my colleague, Natalie, to talk about the other regulation of flavored cigars. So we have a ton of resources on our website with a lot more detail than this slide, but I just wanted to give you an overview, and we wanted to have a lot of time for questions so we can get at the specific areas that you would like more information. But I know Stephanie will put links in the chat so you can see we have a publication and a little video on how to submit a comment to the FDA. We have talking points for your comment on the menthol regulation and separate talking points for the comment on the cigar regulation. So there's just a lot of information that we're happy to share with you. But the big takeaways for the proposed menthol rule is, first and foremost, it's a good rule. It is an important, if overdue, rule. It will get the most harmful tobacco product on the market today off. It is the single most impactful action the FDA can take today to reduce health disparities. So it is cause for celebration. We need to get this rule implemented and enforced as soon as possible, but it's a good rule. It isn't a perfect rule. There are some things that could be made better. And so right now there is a public commenting period that we hope you will participate in to urge the FDA to make the rule even stronger before it is published as a final rule. So first of all, it doesn't address menthol as an additive in cigarettes. And this is important because menthol cigarettes that are packaged and sold, labeled as menthol cigarettes, are about a third of the cigarette market. But menthol is in about 90% of all cigarettes at some level. So for those that it's not the characterizing flavor, it is a subliminal level, but it's added to cool and smooth the harshness of tobacco. So even if you can't perceive it as the flavor of the product, it is facilitating your consumption of the product. And as Dr. Phil says, it makes the poison go down easier. So the FDA has the authority to get rid of menthol at any level in any cigarette. And we wish the agency would do so if they can, and they should now. In addition, if they're not going to get rid of it as an additive, what they're saying in the proposed rule is that they will prohibit it as a characterizing flavor. And this is difficult because characterizing flavor is not a defined term. And so what the agency has done, the Tobacco Control Act, when it was passed in 2009, prohibiting those other flavors in cigarettes, it prohibited them as characterizing flavors in cigarettes, which it never defined, and the FDA has never defined since then. So what in practice then what has happened is that the tobacco manufacturers sort of decide whether or not it's a menthol cigarette or not by how they market it and package it. And I don't think we should ever rely on adjudicated racketeers to be honest with us about their products. And I bet you agree. And I think we should tell the FDA the same thing. So a better definition of characterizing flavor would be helpful for enforcement. It's also the FDA did include some criteria to provide guidance on how to determine whether something has a characterizing flavor, which I appreciate that the FDA has done. It's a difficult issue to pin down. And so make sure you take a look at the suggested criteria and make your own suggestions about how to make those criteria stronger. And then the proposed rule also indicates that the agency is open to exemptions. It specifically calls out very low nicotine, that's what VLN stands for, very low nicotine cigarettes or heated tobacco. And again, exemptions never protect health. Exemptions are always exploited by the industry. And there's just no reason to have menthol cigarettes in any form on the market. It's always completely harmful. And this is the one product that there's no counterbalance. It's not like other kinds of products that the FDA regulates. Tobacco products are just harmful. And so also in addition to talking about very low nicotine or heated cigarettes, they just said they could maybe have a case-by-case exemption process, which seems like a terrible idea to me. And again, we have to always be thinking about protecting the public health and advancing health equity, and exemptions never do that. And the FDA must not allow exemptions in the final rule. And then I just wanted to mention a couple of opposition arguments that you're probably already hearing. There's been a huge push from the tobacco industry for many years to try to link police violence against African Americans with enforcement of public health policy. And then also they are always raising the specter of illicit trade. And so it's really important to think through these issues and be able to talk about them with community members, because there is a big problem with police violence against the African American community. There can be no question of that. It's a problem. It's a public health problem. It's a social justice problem. And as a public health community, we need to care about it and ensure that any policies that we are promoting and advancing do not exacerbate this historic and systematic institutionalized injustice. That said, the proposed rule does not exacerbate this harm. The proposed rule only focuses regulation and restriction on the tobacco industry, the manufacturers and distributors, as they should. And the FDA does not have the authority, nor does this create any direction to monitor or criminalize or enforce against individual possession or use of the product. So we have some resources on that as well, but I strongly encourage you to look at the resources developed by the African American Tobacco Control Leadership Council and the Center for Black Health and Equity as well, to make sure you really deeply understand and can respond to these spurious arguments. And I just want to say, Ms. Carol Magruder was quoted in an article, I think in the New York Times recently, just talking about the incredible level of cynicism of the tobacco industry to try to exploit the Black community's pain for its own profit. And I found that really powerful. And I think we have to make sure that the industry isn't able to subvert these arguments, because getting menthol cigarettes off the market is a social justice issue. It's specifically about reducing health disparities. And then the illicit trade piece too, there are things the FDA can and should do to better limit the potential for illicit trade, and we have been calling on them to do those things for a long time, and that's something you could include in your comment. But the the problem of illicit trade is something to be managed, but it cannot prevent us from taking the protective public health measures that we know are necessary. So it's not a legitimate argument. And we have some resources for you about that as well. And I think there are other folks who are well equipped to respond to that particular piece, including the National Association of Attorneys General, for example, and other enforcement folks. So with that, I'm going to turn it over to my colleague, Natalie, to talk about the cigar regulation.
Sorry, I lost my unmute button and I couldn't find it. Okay. You don't actually have to look up what the FDA said about characterizing flavors because I went ahead and put it on a slide for you. And I'm going to talk about the cigar regulation, but the menthol proposed rule and the cigar proposed rule pretty much bring up a lot of the same issues. So I'll try not to be repetitive, but I thought I would provide you sort of this information about characterizing flavors that the FDA provides. And as Joelle said, it's not defined, but the FDA just notes that these are the things they're going to look at, which is even more sort of extreme way to get around actually defining and making a more specific standard about what characterizing flavor even means. If you look at this, it's pretty similar to a lot of the language that we use in local regulations. So like using the multisensory experience, we use that in local model language and flavor representations, so like what the packaging looks like. And part of the reason that we use that at the local level, maybe perhaps not the only reason, but one of the reasons that we use at the local level is that local states, tribes don't have the resources to actually know or the authority to know exactly what's in all these products or test for flavor additives and things like that. But we've always acknowledged that the FDA does. So it's a little bit disappointing to know that the FDA maybe could adopt a different standard that would be more robust because they have the resources to do so, and instead seem to sort of mirror some of the experiences or some of the, principles that local flavor prohibitions use. We've gotten a lot of questions about what does the regulation exactly say and what does it cover, and I guess oh, you know what? I should back up and say, I think Joelle said this at the beginning too, but we should give props where props are due in the sense that when the FDA or when the Tobacco Control Act was signed into law, and Joelle was talking about that, they did prohibit characterizing flavors other than menthol and cigarettes, and it wasn't defined then either. But what ended up happening was that little cigars emerged in a variety of flavors. And so the definition of cigarette is like a roll of tobacco and paper, and the definition of cigar is a roll of tobacco and anything other than paper, thereabouts. And so little cigars emerged, which just have a little bit of tobacco in the paper. And, that was an undermining of that rule or of that law, that provision in the law. And so it's a good forward-thinking thing on the FDA's part to address characterizing flavors in cigars so that those are not able to continue to undermine the rule, the menthol rule. And so we get questions about what's included. And so this slide is trying to get to that. So little cigars are included. So I have a picture there, the Swisher Sweets little cigars, and then cigarillos. I have a picture of Black and Mild. That's an example of cigarillos. And then I say excluded, and I put sort of under premium cigars because by definition, premium cigars cannot have characterizing flavors. So there's already, a prohibition on characterizing flavors in premium cigars. So in this regulation, the FDA doesn't include them in the regulation, but that's because there's already no characterizing flavors in premium cigars. And if they if premium cigars tried to add characterizing flavors to, undermine this rule, when they do that, they no longer are premium cigars and they are subject to this rule. So there's no real way to get around this rule in the realm of what are cigars and all the different types of cigars. The other thing that isn't included in either, and Joelle mentioned this a little bit in her section, in either rule is e-cigarettes, and I put in here in parentheses for the menthol, especially when we wrote the original petition, the FDA didn't even have authority over e-cigarettes, and we didn't include cigars in the original petition either because the FDA also didn't have authority over cigars at that time. But e-cigarettes aren't part of either rule, and it's unlikely that you could comment about this and you could talk about this, but it's unlikely that the FDA would make a change to the rule as part of that comment because they have to give notice and they're not including them in this rule. So they would have to probably restart a rulemaking process to give notice to e-cigarettes that they are being considered as part of a flavor or menthol restriction. And the FDA, what you'll notice when you look at if you go ahead and look at the actual regulatory information, they ask a lot of questions. And one of the questions they're asking is, they can think of two other combustible categories of products that exist that haven't had flavors addressed in, which is water pipe tobacco and pipe tobacco. And so they ask, is there evidence to support including them also in this? And different than e-cigarettes that, they're not asking about in this rule, this would be like notice to water pipe and pipe tobacco manufacturers that the FDA is considering this. So some of the potential weaknesses of this, and Joelle got to this, is that the characterizing flavor approach is possibly too broad and is like not really binding on the FDA to take any particular approach. And what we intend to recommend in our comment is that the FDA take the approach of no flavor additives, period. And rather than trying to define characterizing flavor, that they just take this more strict approach that is no flavor additives at all. And like I said, when I was first talking about characterizing flavor, the FDA actually has the resources and ability to test that and to enforce that. And then I think what we'll say in our comment as well is that assuming the FDA doesn't take the most protective of public health option, which is no flavor additives, period. Alternatively, we think that the FDA should actually define characterizing flavor, and that the best approach with that would be to actually establish amounts cutoffs for all the known flavor additives. So do the research, gather the research and know exactly what would be a characterizing flavor and what wouldn't be a characterizing flavor for each flavor additive, to try to make this more strict and more clear, and have more protection on public health. Another potential weakness is the timing, and this applies to both of the rules. So oftentimes the FDA, I think probably every rule that they have ever proposed, someone somewhere asked to extend the comment period longer than the provided time initially. And usually the FDA grants it, but we wrote a comment to the FDA saying, please do not do this. There's so much evidence about menthol especially, but even about flavored cigars, that really as quickly as you can do this is the best. And that also goes for shortening the effective date. So typically, all rules have a sort of standard 1 year effective date from the final rule being published. But the secretary or the FDA has the option to actually shorten that if there's reasons that exist. And we think saving lives is a good enough reason for the secretary to say, actually, we're going to make this effective date a lot shorter. So Joelle mentioned this as well. I just kind of screen grabbed them so that you could see what they look like when you're looking for them. And I know that Stephanie put so many links in the chat for you, but this is what our talking points are, each one page long, about talking points that hopefully can help you think through the things you might want to say in the comment, besides maybe answering the questions that the FDA asked. And we had a question to, do we need to try to like think of an answer for every question the FDA asks? And the answer is no. You can talk about what's, the most important points to you and what you have like the most authority and knowledge about, and address those things. And you can address things that the FDA doesn't ask. This is a sort of a timeline about how this will actually work. So the top is the publication date. So May 3rd, 2022 is when they actually put it in the Federal Register. They announced it on April 28th, but it didn't show up in the Federal Register until May 3rd, 2022. So that's the starting point, the starting date. And then that means that the public comment period closes 90 days after that, which is July 5th, 2022. So that's when you will want to get your comment in by, if you're going to comment. And like I said, that could get extended, but we're hoping that the FDA does not extend it and that we are able to go ahead and have that July date be that date. So the next two steps are that the FDA has to read through and compile all the comments, and then they publish the final rule. And both those things don't have any time limits. So you never know how long it's going to take to get through all the comments. But the FDA gets through all of them, reads through all of them, and then they publish a final rule. And so both of those dates are sort of unknown and up to the FDA, but hopefully it will happen as soon as possible. And then, like I said before, typically the effective date would be 1 year after the publication of the final rule, but that could be shortened, and we intend to comment that the FDA should shorten it. And then ultimately, there will likely be litigation challenges. And so we won't know whether any of those litigation challenges will slow down the process or what will happen necessarily with that. But it's inevitable that we will have litigation challenges. And so that's sort of the last aspect of the timeline that is going to be sort of an unknown factor of like the question, when will we actually see all these products off the market? We're at a good place because we've actually started step one, but we have some like unknown amounts of times and unknown factors that we can't exactly answer that question. And I know that Stephanie already put these in the chat, but this is what it looks like. So we have a regulatory tracker on our website, and this is what I did a screen grab of what it looks like. So under the top right docket, if you click on that FDA, I don't know if you can see it, but FDA 2021 thing right there, you will go to the regulatory page where you actually submit the comment. This video here, Stephanie put a link in the chat as well directly to this video, but embedded on this website, the video is how do you submit a comment. It's about 7 minutes long. It just walks you entirely through it. And then we have some hyperlinks resources, and we have some more resources on the bottom right below that should help you in being able to submit a comment to the FDA. And then I know someone asked in the chat about whether, or maybe in the questions about whether these slides will be available. They will be available on our website because we record all our webinars, and we always include the slides there. And so I've hyperlinked these two as well. So when you get the slides, you can also click on these two hyperlinks to get to where you need to go. I think the last take home about this is I showed you that timeline. There's lots of unknown dates, including litigation, which can go on forever and ever. So, the ultimate message is don't wait on the FDA. It's a really great step. We're very excited about it. We want to see it happen. We know it will save lives, but in the meantime, local, tribal, and state work are still so incredibly important, and we still need to keep pushing forward on flavor restrictions in our communities. And then also, we've tried to share as many resources as possible to help you feel comfortable with the comment process. And you're welcome to email me as well and ask any questions about commenting. But honestly, you all are the experts on flavor restrictions, sales restrictions. So it's definitely appropriate and great to submit any of your local data and experiences, and even, talking about why, it's a challenge to implement some of these policies sometimes because you can't test the products for flavor additives, and saying, that could encourage the FDA to take a different approach than what is done at the local or state or tribal level. So feel free to, share your local data or experiences, anecdotally is fine too. The FDA has to read every comment, so you're the experts on this, and you should definitely share your information that you have. All right, I'm going to stop sharing because now we can answer all the questions you have.
And I will jump in. Thank you, Natalie and Joelle, for getting us started on this. It looks like we had a few questions come in while you were presenting. I think I'll start with this one, Joelle, because you had indicated you'd like to answer it regarding concept flavors. So the attendee asked, are concept flavors like Purple Swish or Summer Twist covered under the flavored cigar ban?
That is a great question. Concept flavors have been the nemesis of communities across the country who have been trying to get flavored tobacco products off of the shelves in their community. And so when Natalie just at the end there was talking about characterizing flavors and the importance of a better definition of that, that's absolutely the FDA's role. And what ideally they would structure the definition of concept flavors, or I'm sorry, characterizing flavors in a way that captures all those little squishy, misleadingly named, color coded so people understand kind of products. And so that's something you should include in your comment to the FDA. And I know this is a problem for communities in California because I provided TA on this topic as recently as last week. But it's also something that has been a problem since the very first flavor policies were passed in Providence, Rhode Island, and New York City. So I think this is a big part of what you need from the FDA. The FDA has the capacity to test products or require ingredient disclosures and all of that states and locals don't really have the capacity to do. And the FDA has the authority to do it. And so you need the FDA to do their part here, because if the FDA is ensuring that products are determined to be flavored or not, based on all of the information the FDA has, then it won't be up to you to try to make the case on a product by product basis in your community. So absolutely share your information, photos of what you're seeing in your community, how you have tried to tackle this problem. All of that's really important for the FDA to hear.
Yeah, well, and one thing to mention too is that the FDA should already know all this information because they already require all of these products to submit ingredient lists. So that's not information that states and locals and tribes can gather from the tobacco industry because it's proprietary information, but the FDA already has it. So exactly what Joelle was saying, they are well suited to do this. They have the authority to do this, and there's no reason not to take the very best approach in this and, be able to successfully make this more public health protective.
Yeah, I would also just say, I think that locals have always been the leaders in tobacco control. And when the FDA got authority and kind of got into the game, it's never really been designed so they would do it all, but also they are incapable of doing it all, but they do need to do their part. So they have authority to for example, implement a track and trace program that would tamp down on illicit trade. They have this exact authority that Natalie and I were talking about of identifying which products are flavored, and we need them to do their part so you can do your part. But they'll never be out ahead of you. You will continue to lead the way, and then they also will be under serious attack from the industry they have been this whole time, and they will continue to be. We know litigation will come, so don't stop the good work you're doing. But also what we're calling on the FDA to do here is be a full partner to the states and communities who have been leading this work for decades.
So continuing on then with what can people be doing at that local, even at that state level? Natalie, I'll kick this over to you because you had addressed this question in part in your part of the presentation, so maybe you can continue on in that thread. The question is, if this proposal passes, when are retailers and tobacco brands expected to start enforcement of this ban? If we are monitoring tobacco brand and retailer websites, when should we expect all flavored cigar products be removed to comply with the FDA proposal /ban?
Everyone's favorite question, and it's the least satisfying answer, which is we don't know. And it's up to a lot of different factors. So the FDA has some steps that it has to take that don't have any particular deadline. So they have to look through all the comments, and then they have to write a final rule and put that on the Federal Register. And then the other big factor in that has taken historically, I would say, about a year. But it's not like the FDA has done a ton of rules or in the past, so it's not like we have a lot of data to say what their average is on being able to do that. So I don't know exactly how long that will take them. But the other big factor is litigation, and that can slow things down for years, unfortunately. That's not an answer I want to say, but it's a true answer. And, the courts have a tendency, it's like this idea that you keep the status quo. And the status quo, unfortunately, right now is menthol cigarettes being available and flavored little cigars or flavored cigars being available. And so there's a tendency possibly that the FDA or that the courts might say, well, we're going to keep that until we resolve this. And that can take years. So that's why I was also emphasizing that all of our local work, all of our state and tribal work, that's so important, because we just don't know when we can expect these to be removed.
Can I jump in there, Neil, and just add a couple of things?
No.
I'm going to talk anyway. So the one example we can look to is the FDA's deeming regulation that was proposed in May of 2014 and wasn't final until May of 2016. And that is a long time, 2 years. But there's a lot of differences between that rule and this rule, especially the menthol rule, which is only adding menthol to a list of otherwise prohibited flavors in cigarettes. So that it's all set up. We're just taking the worst flavor off the market, like we took other flavors off the market. The deeming rule was setting up a whole new infrastructure for products and companies that had not been regulated. And this is really just removing an exemption from an existing rule. And then in the case of the cigars, creating an analogous rule. And so there's that. Plus, the FDA has been collecting so much information about the problem of menthol and flavors the entire time they've had authority to regulate tobacco products. We talked about the TPSAC report in 2011. When we filed our citizen petition, it created a docket for public comment as well. And we received first about 1,000 and since then another 1,000 comments. Also, in July of 2013, the FDA issued the ANPRM, opening another docket for public comment. In 2018, they did another ANPRM with another docket. So this is the fourth docket for public comment on menthol in tobacco products. And so the FDA has had a lot of time to think about it. The industry has had a lot of opportunities to submit their information. And so it should not take as long for the agency to go through the public comments, assimilate that information, respond to it, and put out a really strong final rule. And then for litigation, I guess I also wanted to mention the litigation that might be giving you all a heart attack right now is the graphic health warning rule, which has been completely paralyzed by litigation for many years, twice. It was struck down one time and then they promulgated a new rule, and it's still on hold because of multiple lawsuits. And I just want to offer that that does not mean that this rule would be held up the same way. The deeming rule was subject to a whole bunch of lawsuits as well, and they managed to overcome those barriers and get it out into the world. And I'm hopeful that the menthol cigarette rule will be the same. And I just want to remind us all that, the First Amendment issues at stake with a warning label like the graphic health warning rule are much harder in court. It's just a high barrier to overcome, even though we know the public health benefit of that rule would be significant. The industry might say they have a First Amendment stake in continuing to market menthol cigarettes, but I don't think it's going to be the same consideration. So I think we can hold out hope that a court would not stay the rule. And the most important thing, the industry can have a tantrum in court as long as they want, but we need the rule to get into effect so it can start saving lives.
Continuing on then, there are quite a few good questions here, so we'll try and get to all of them. I'd like to start with what I think will be a fairly easy one. Joelle, since you were just sort of, I think you had a few comments on this in your presentation, so did Natalie, so either one of you could address this. Would comments from teenage students be helpful? The asker is thinking about potential assignments to give to young people.
Delightful. I have a 14-year-old who perhaps will be required to submit a comment to the docket as well. The thing that anything is helpful, I would say, except for a signature petition style or identical postcards, that kind of campaign, that is not helpful to the FDA. What they are looking for is new information, perspectives, experiences at the community level with how these products are marketed and sold and causing initiation and addiction. So if a teenager can comment on the presence of menthol cigarettes in their community, of the ubiquity of tobacco retailers on their walk to and from school, for example, of the generational harm in their family caused by smoking menthol cigarettes, that would probably be meaningful to the FDA. But this isn't the same as a political thing where they're kind of tallying how many people say this, I agree with this, or I disagree with this. They have to ground their regulation in the science and the law. And they've done that here with this rule for the most part, as long as they've removed the things we don't like, but it still is a good rule. But so, you want to avoid a situation where you're just trying to clog the docket, because the FDA will just batch all of those together and dispose of them. So it doesn't advance their thinking at all. But if you want to have a, youth perspective on the harms of tobacco use, I think that's very useful and very relevant to the agency's consideration of how this impacts young people.
Well, and I think what Joelle's saying too is like you could ask them to collectively write one that shares all their experiences. You wouldn't necessarily have to have 30 of them, because that's just getting the information to the FDA. It doesn't really, the volume of the number of comments doesn't necessarily matter. But Joelle was saying menthol cigarettes, but also flavored cigars, so we could talk about that too.
Sorry. It's all equally important.
There's a very related question about what might be 3 points to provide education comment for. It sounds like you both touched on a couple of them. Would there be anything else that maybe people thinking about writing a comment would want to provide as a perspective, or something that otherwise FDA would need to and want to review as a comment?
You want to take that one, Natalie?
Well, so I guess 3. I don't 3 per comment or per proposal, but yeah, Joelle, if you can think of 3.
Well, Carol, I would just say that the talking points identify the things, the most important things we think that need to be addressed in comments. Beyond that, I think it is really important that the folks most disproportionately harmed by these products are represented in the comments. And so I think making sure that you are supporting African Americans and LGBTQ plus folks who have been so targeted, and giving them the opportunity to share their information and data and experiences in this docket. I think that is both worth the effort because it's important for the FDA, but it's also the right thing to do, that no one knows better of the devastation caused by the tobacco industry with these products than the communities who have been targeted historically.
And I think that maybe one of the most important things in my mind too, besides that. So like, I think on our talking points thing, that's one of the things near the top is like health equity, and then like focusing on that. And I think that's exactly what Joelle is saying there. And I think the other thing is that California communities and other communities just really could speak to is, this idea of characterizing flavor, how you approach it, how difficult enforcement has been, like sharing that, like honestly, and then in that encouraging the FDA to take an additive approach rather than this characterizing flavor approach.
Natalie, I'm going to keep you on the hot seat for a moment. I think this is a very good question for you to start off on, and for Joelle maybe to finish out as well with your thoughts. Is there potential that coming down on illegal trade could criminalize the BIPOC communities? And this is something we, three of us and our colleagues have all talked about as well. It's also not that anonymous attendee, you were intentionally doing this, but it is something of the refrain that we hear from people who oppose, some of the people who oppose the menthol rule in particular, and maybe by extension, the cigar rule. So Natalie, if you would like to answer that question.
Yeah, some of this stems from this idea of illicit trade where someone is selling cigarettes on the corner where they've bought cigarettes in a state that doesn't charge as much taxes and goes ahead and sells them in a state that charges a lot more taxes for less price than what people could get at the store because they're charging taxes. And that is, like a state by state thing that causes that issue. And so that is brought up a lot, but this will be a nationwide and territories rule that won't create like differences of availability between one state or another, or one jurisdiction or another. So that's like one important thing to know, that like that's brought up a lot in these scenarios, and that's really a state by state thing that isn't impacted here. And Joelle made points about this before too, so I'll let you go ahead and make those points again, Joelle.
Well, I just think that this is important, and we can't ignore the problem of unfair, racist, biased policing and enforcement efforts in our work to protect health. So there cannot be this kind of over focus on the targeted addicted users. And that's what happens when you criminalize possession, use, and purchase, for example. So in all efforts there to get these products off the market, the penalties and restriction and enforcement needs to be focused on the source of the problem, which is the tobacco industry. And what the FDA is proposing for this rule does focus it on the manufacturers and distributors. And I did copy some of the language from the rule and put it in the Q&A box for the questioner who asked about enforcement efforts. And the FDA is very clear in the proposed rule, again, themselves, that there's no effort to target individuals or consumers with this. I would also add that, just to make it a little more disgusting how the industry operates, the industry itself perpetuates illicit trade. They overproduce in a certain country with the understanding and expectation that the excess tobacco products will cross borders. I mean, there's a lot there. So I think that it's up to us as advocates and big thinkers for public health and the FDA as the agency with the authority to make sure that we're crafting the enforcement efforts and creating the tools that focus on restricting a terrible actor, which is the tobacco industry. The track and trace example that we gave to earlier, that's something that actually the Tobacco Control Act, I think, requires the FDA to implement, but they have never done it. In 2013, turns out it was a big year for citizen petitions. We joined a citizen petition calling on the FDA to take that action that was led by the New York City Health Department, and they still haven't done it. But what that would do is basically just require the identification of the product so you could trace its path into the illegal market. So you could figure out what the problem is and where it's coming from and who the manufacturer is that's causing this problem or who the distributor is that's causing the problem. So that's another example of a tool being designed to focus on the industry as it should. But none of this is to say that this won't be an ongoing challenge for us to make sure that there isn't a creep into local policing of individual community members, which cannot be part of this plan.
Okay, a couple more questions. And of course, by all means, shoot your questions our way. And if you think of questions afterwards, you can email any of us at the Public Health Law Center. We're happy to try and work through some of these really interesting and thoughtful, thought-provoking queries about how this rule might affect people. Speaking of, Natalie and Joelle, either one of you can take lead on this. One of our attendees asked a really good question about federalism. Does the proposed rule currently include any preemption language that might affect local or state level flavor policies?
The answer is no. So the Tobacco Control Act has some preemption language about product standards, but has like preservation language, savings language for localities to still do sales restrictions, which is how all localities have addressed flavors historically, and the courts have upheld that is within the locality's authority to address flavors through sales prohibitions. And that is a savings part of the Tobacco Control Act. The FDA could not, I think this is true. I don't think that they could, through a proposed rule, change the preemption language. It would have to be an act of Congress to change the preemption language in the Tobacco Control Act. They'd have to actually amend the law. So no, the simple answer is no. And also it was quite impossible for them to do this mechanism.
And I would only add that it's actually preserved as well as saved. And that's a nerdy answer that only a lawyer would love, but it's important that there are, the Tobacco Control Act says that twice, that authority is for the states as well. And so that's a great question from Ariel, that we want to make sure that states and locals are continuing to think beyond what the FDA is doing and doing more to be more protective, because you can. And the authority to restrict or prohibit sales is one of the most effective ways to do that. And you have that authority under the Act.
And also a small plug for the fact that the FDA technically cannot eliminate all tobacco products. They cannot just say no more tobacco products can be on the market at all, but localities can and have. And so, and in California being the best example of that. So that's one example of being able to go further than the FDA can go.
Can I really quick answer Dr. Novotny's question, Neil?
Yeah, I was about to say we have one left. It'll probably be our last one. So Joelle, if you want to kick us off with Dr. Novotny's question.
Filters. So I just want to, give huge credit to you, Dr. Novotny, for your leadership on the issue of filters and tobacco product waste more broadly. This is a issue that has been long on the margins of commercial tobacco control policy change, and you are right that it should be front and center. We don't want to leave any tools in the toolbox when we could be using them to restrict the products. I would say that filters and menthol and other products are all examples of why tobacco products shouldn't be sold at all, that the industry should be eliminated. And I think every time we talk about the environmental harms, that's what I think of, is that this is why no exemptions are a good idea. This is why we shouldn't have the industry allowed to pretend to be a good corporate citizen by organizing a beach cleanup. It's a bad industry. Its whole business model relies on addiction, illness, and death. And then for all the environmental reasons as well as the human health reasons, it should end. But that is actually not what the FDA is proposing to do. But that's why leadership in California communities is so important.
that's probably, and just a comment that's probably one of, I agree with you. It's one of the things that would get the FDA the closest to endgame than that they have authority to do without actually banning, like I was saying, they can't actually ban all tobacco products or a category of tobacco products. And that would be one of the things that get them the closest to that, even I think more than like low nicotine cigarettes.
And they also are not allowed to reduce or to eliminate nicotine. That's a limitation in the act, but they can reduce it so it's not addictive, which they can and should do as well. But that's a story for another webinar.
And that does bring us to the top of the hour. I don't see any more questions in our Q&A queue. So I will be the first to thank Joelle and Natalie for shepherding us through this very complex thing that's happening, the result of almost a decade, probably more than a decade of effort from partners as well as the Public Health Law Center. And I will thank you for your time, your expertise. Anyone on the call who has questions that maybe come after this conversation, by all means, shoot an email our way. We're more than happy to take the time necessary to answer them to the best of our ability, even if, as Natalie herself said, sometimes we just don't know the answer, but sometimes that is the answer. So with that, thank you both. Thank you, Stephanie, as well. And thank all of you for giving us a little bit of your afternoon or morning, whatever time of day it is for you. We might have someone phoning in from Hawaii. I don't know.